Martin later. Now, in 2 days' time, the centuries-old verdict of not proven will be consigned to the history books. It's the culmination of years of pressure from campaigners, chief among them Joe and Kate Duffy, whose daughter was murdered in 1992. Our Home Affairs correspondent David Cowan has been speaking to Joe and looking back at the story of the long-running campaign for change.
In May 1992, news bulletins reported the murder of a 19-year-old girl from Hamilton.
Amanda's parents described their daughter as a happy, bright girl who lived for drama. She attended Motherwell College but had gone out on Friday night to celebrate getting an audition for the Royal Academy in Glasgow. Her parents
Amanda Duffy's body had been found on waste ground, the victim of an exceptionally brutal crime. Her distraught parents, Kate and Joe, spoke to the media in the hope it would help catch her killer.
His clothes must have been covered in blood. There'll be scratches on him. He's not normal. He's definitely not normal.
He can do this to this extent, this frenzied attack. He can do it once, he can do it more than once.
The 8 women and 7-man jury took just a few hours to reach their verdict at the High Court in Glasgow. They found the charge against 20-year-old Frances Auld from Eddlewood in Hamilton not proven. A verdict which brought angry screams and shouts from relatives of Amanda Duffy.
Can I take you back to the High Court in November 1992 when the verdict was returned that day? After 33 years, Joe Duffy recalls what happened.
We were completely taken aback because the first thing is we had no idea what not proven actually meant. No idea whatsoever. Nobody had ever mentioned it to us. All the information from the police and the fiscal service all the way through where we've got a very strong case, we expect to get a guilty verdict, etc., etc. And then when the judge says basically you're acquitted and you're free to go, you're thinking there's something wrong here somewhere. Right, hang on a minute. What on earth is not proven? And that's when it all started.
The Duffys felt they had been denied justice. They learned there's no legal definition of not proven. Within weeks of the verdict, they were back in the news.
The Duffys say the response to their campaign has been overwhelming, and they now believe the abolition of the not proven verdict is an issue of national importance.
With a not proven verdict, you come out of that trial feeling that you have a life sentence.
Have you ever been able to satisfy yourself about what it actually means?
No, I've never understood exactly why it would be there. Unless, of course, you're a defence counsel.
Their MP, George Robertson, put forward a private member's bill at Westminster proposing abolition, but it failed to get the support of the then Conservative government. The Duffys saw that as a stumbling block rather than a knockout blow. They didn't give up. But it was 2015 before another case signalled the beginning of the end for the verdict.
The campaign to abolish not proven is led by Miss M, the former St Andrews University student who has just won £80,000 in damages in a civil case against Stephen Coxon. He was acquitted in a criminal court. The jury found the case was not proven, but last month a civil judgment branded him a rapist.
Backed by Rape Crisis Scotland, she began a new campaign for the abolition of not proven, echoing what the Duffys had said many years before.
I didn't understand the difference between not proven and not guilty.
Members of the legal profession argued that not proven was a safeguard against a miscarriage of justice. But this time, abolition had cross-party support. And in September, with Miss M and the Duffys watching from the public gallery, Parliament backed legislation put forward by the Scottish Government. It could be years before the consequences of all of this become clear. But from Thursday, Scotland's third verdict will be consigned to the history books.
We started 33 years ago to try and have not proven abolished. And there was an awful lot of false dawns along the way where you think, OK, it's getting somewhere, there's an interest in it. There was always a lot of objections to the idea of it. We've never given up, let's put it that way. So I think for anybody that's out there that wants to campaign for something and thinks there's something that's changed, don't stop, keep going for it, because it may have taken us 33 years, but you know something, we finally got there.
His wife, Kate, told the BBC there's some solace in the fact that no other family will have to go through this. There's relief and a feeling of vindication, but most importantly, it's for our daughter. It's for Amanda.
That's our Home Affairs correspondent David Cowan reporting there. Well, as we heard there, some in the legal profession have reservations about scrapping Scotland's third verdict. Thomas Ross, KC, is an advocate and defence specialist and joins me now. Afternoon to you.
Hi, good afternoon.
What do you make then of this attempt to reform the Scottish trial system?
It's an act of self-mutilation. I mean, Scotland by accident fell upon the ideal system, which absolutely suits the function of a jury perfectly, namely to decide whether the case has been proven beyond reasonable doubt or not. And we were ahead of the world in that, and it's been torn up for no good reason.
But do you appreciate that, as we heard in the report there is a sense of confusion about it? People don't understand it. It seems that even jurors don't seem to be given a clear definition of the verdict, or indeed how to use it.
Yeah, I mean, that could easily have been remedied by doing away with the not guilty verdict, because the question for the jury is really a binary question, namely, has the charge been proved beyond reasonable doubt or not? So that question could be answered yes or no, or it could be answered proven or not proven, So I absolutely agree with the idea that the jury should have two verdicts, but the verdict should simply be proven or not proven. That would simplify it. But, if the purpose had been to create a fairer trial system, or even to create a trial system which drew envy from other countries in the world, that's what we would have done. But clearly the purpose is to obtain more convictions.
And do you think that really will be the case?
Yes, I do. I think people
Why?
who would... Because in many, many cases, and the focus has been on sexual offence cases, in many of those cases, clearly the jury cannot distinguish between the credibility of the complainer and the credibility of the accused. So either they believe them both, or they don't believe either of them. And in those circumstances, the not proven verdict is the perfect system. Now, they won't be able to do that. Now, you think if you found yourself in that position as a juror, you might think it was going too far to declare the accused as not guilty, because that could be taken as a rejection of the credibility of the complainer, who they believe just as much as the accused. So, although it's claimed that this will reduce confusion, it's actually more likely to create confusion, because the jury will think, well, where do we go here? Because we're not prepared to go so far as to declare this person as innocent, which I suppose they might think a not guilty verdict means. Whereas in 2025, that person would have been found not proven and wouldn't have been sent to prison, put in the sex offenders register, and all the other consequences that fall from it.
It's interesting because some of the research done into sort of jury behaviour, the Scottish jury research suggested that mock jurors sometimes used it as a compromise verdict to bring deliberations to an end, rather than, have to carry out protracted, difficult discussions on reaching a verdict. Surely that's not what it was intended for.
Well, it's simply intended to communicate to the judge whether the charge was proved beyond reasonable doubt or not. But, we have to be clear about this. We haven't spoken to any jurors. These people... Well,
as I say, it's a simulation. It's as close as you can get, really.
Exactly. Yeah. It's like, asking Joe Pesci about questioning witnesses because he once pretended to be a lawyer. These people were pretending to be jurors. They weren't jurors. I mean, it's a hard job being a juror because... they know that there are consequences in relation to the verdict that might result in a 18-year-old kid going to prison for 6 or 7 years. These are the pressures. The people in the mock jury study didn't have any of those pressures. So the idea that we would reform the law on the basis that we're basically playing at it for £50 expenses, that doesn't strike me as a particularly sensible way to go about law reform.
And there are other safeguards here, notably the jury threshold being raised to 10 out of 15 majority rather than 8. Does that allay some of your concerns about not proven going?
No, it doesn't, because, all the cases at the moment which end in acquittals might have 10 in favour. I don't know. We don't get to... Because we don't speak to any jurors, we don't know anything about majorities. What I would say is in England, where there are only 12 jurors, there has to be 10 for a conviction, which is clearly a much higher rate than even the new system is going to bring in Scotland. So, no, I suppose I'm going too far to say that it doesn't allay any fears, because obviously it makes it more difficult for the Crown to obtain a conviction. But, I'm still concerned that in those marginal cases where not proven was the ideal verdict for the jury to return, that miscarriages of justice will result.
And this has been campaigners, we heard in the piece earlier there, a lot of campaigners, have pushed for this because of the difficulty they feel in getting convictions in rape or in sexual offence cases. They believe that the not proven is disproportionately used in these type of cases. Is that a concern that perhaps it's used because jurors just, I don't know, don't feel that a case has been proved beyond reasonable doubt, but yet, they do have a doubt when it comes to the accused?
Well, if they feel that the case has not been proved beyond reasonable doubt, they should acquit. That's the nature of the system. And obviously in litigation, people are going to be disappointed. But I mean, let's be clear about this. In some murder cases, which I don't do sexual offence cases, but in the cases I do, there are often 12 sources of evidence. There's CCTV, there's fingerprints, there's DNA, there's admissions, there's eyewitnesses. And, a lot of sexual offence cases, there's only one witness. So any sensible person would expect there to be more convictions in cases where there are 12 sources of evidence compared to cases where there's one source of evidence. So it's frustrating, and I understand that people will be disappointed. But, it's a consequence of the fact that in these cases, there are simply less sources of evidence, and therefore, if the single witness has misinformed the police about something or has changed their position from when they spoke to the police, it is hard for the jury to be satisfied about their credibility. But that's really a consequence of the fact that there's a very small source of evidence in relation to these cases. And I'm not discounting it. It must be incredibly deflating for the people who are affected by it. But the answer is not to make it easier to put innocent people in prison and put them on the sex offenders register.
Thomas Ross, Casey, thank you very much indeed for joining me.
The search is on for the BBC